Well, welcome. Good afternoon. We are very excited to present our Can't Miss Retirement Plans webinar. My name is David Hall. I'm the firm manager here at Hall Benefits Law, and I wanted to thank you for being here, first of all. This is going to be our best webinar ever. And just a couple of housekeeping items before I introduce our presenters. I wanted to let you know that, first of all, everyone who signed up for this particular webinar is going to receive a free digital version of Ann Tyler Hall's new book. Ann Tyler Hall, as some of you may know, is our founding attorney and principal attorney here at Hall Benefits Law. And her new book, Case Studies in ERISA, Why It Matters and How It Benefits You, is currently the #1 new release in corporate law on Amazon, a very hot and heavy section of Amazon. So if you would like to purchase your book, you can go onto Amazon. The easiest way to find this book is to search Ann Tyler Hall, and it is currently available for Kindle at a special price of 99 cents, and you can also purchase a paperback version of that book. However, for you who are tuned in now, a physical copy may be obtained by emailing admin@hallbenefitslaw.com, and if in the subject line you will please put book and be sure to include your mailing address, we will be happy to send you a copy of that book to use or to share with a client or with someone in your organization who you think might benefit from reviewing some case studies that our team has had an opportunity to work on in the areas of executive compensation, health and welfare benefits, retirement plans, fiduciary exposure and ERISA litigation, ESOPs, and employee benefits in corporate transactions, as well as healthcare reform. So it's a very easy to read and easy to understand book. And I think that each of you are here because you are in the benefits space, and I think you would benefit from it. So the next item on the pre-agenda is that we're going to have a special announcement at the end of the first section of our webinar. So please stay tuned. If you're going to drop off, don't drop off before the end of Charlene's section, because we're going to do a special giveaway, and I would like everybody to have an opportunity to benefit from that. So without further ado, I would like to introduce you to our presenters. These are three very accomplished and capable attorneys that we're proud to have on our team here at Hall Benefits Law. First of all, and speaking first, will be Charlene Barnwell. She is Senior ERISA Compliance Counsel here with Hall Benefits Law. She has a background as in-house corporate attorney for a large corporation headquartered here in Atlanta. Deborah Andrews is our managing attorney. She has a background as not only a tax attorney and benefits attorney, but also as a CPA, currently licensed in the state of North Carolina. Rena Felton is our third and final speaker today. She also is Senior ERISA Compliance Counsel, and Rena is an experienced and accomplished attorney who has actually taught university level classes on ERISA. So keep your ears open. We have a full agenda today. There's lots to know. We will be sending you a copy of the slide deck, so if you miss something, please don't worry. We'll make sure you get a copy of the recording as well so that you can listen back. Okay, so just a brief, in brief, let me cover what we're going to talk about today. We're going to talk about student loans. This is a hot topic currently in the benefits space. Hardship withdrawals, multiple employer plans or MEPs, the Secure Act of 2019. We'll be talking about missing participants, how to address missing participants, and then retirement plan correction program update. And you'll notice there's a red exclamation point there because I wanted to point out that there's a little bit of a nugget of wisdom here that you will only get from Hall Benefits Law because of a conversation we just recently had with the IRS. So looking forward to hearing that from Rena a little bit later. So please stay tuned through the end of the presentation for that interesting nugget that will benefit you, especially if you're a plan sponsor. All right, let me go ahead and pass the mic to Charlene Barnwell, who's going to kick it off talking about a hot topic, student loans.
Thank you, David, and good afternoon, everyone. As you may know, student loan debt is continuing to be in the headlines, and with good reason. In the US alone, more than 44 million people owe $1.5 trillion in student loan debt, which averaged to more than $34,000 per employer. So, many thanks to an increasing tight labor market and record levels of student loan debt, here's some of the reasons why student loans are considered a hot topic for employers. You know, Americans are burdened by student loan debt more than ever, as I mentioned earlier. As recent as last year, 69% of college students took out student loans. That same year, parents, about 14% of parents took out an average of 35,600 federal loans, parent loans. Student loans have been almost considered 157% in cumulative growth over the last 11 years. And certainly it's, I would say, the Federal Reserve stated that it is definitely considered to be the second largest consumer debt segment in the country this year and last year. So more to come on student loans, but I would say that we will be talking more about what employers should do and some of the things employers have done in relations to student loan assistance program. That takes us to the IRS private letter ruling, which I will talk a little bit more about, specifically a private letter ruling case that was ruled by the IRS in 2017. But right now, let's take a look at some of the concerns so what some employers are having about when or if they consider issuing or implementing a student loan assistance program. There have been previous concerns by employer prior to the private letter ruling in 2017 as to whether the student loan repayment coordinated with a 401k retirement plan, which would be what they would consider a violation of the contingent benefit rule. Contingent benefit rules limit the ability of employers to link certain types of workplace benefits together, leading many companies to avoid adopting policy that pair student loans and retirement savings. So what I have on the screen is Section 401k 4A and Treasury Regulation 1.401k-1E6, which both provides regulations on cash or deferred arrangement of an employer and how it should be treated as whether it should be treated as a qualified cash or deferred arrangement if any other benefit is conditioned on the employee elections. But there's a sentence below that states that the preceding sentence shall not apply to any matching contributions made by reason of such elections. I'm giving you these provisions because in 2017, there was a taxpayer, August 2017, that requested a private letter ruling under Section 401k. It was presumed or believed that taxpayer was Abbott Laboratories. Here are the facts. Abbott Laboratories offered a 401k plan or offers a 401k plan that allows employees to elect to contribute a portion of their compensation. If the employee made an elective contribution equal up to at least 2%, then Abbott Labs makes a matching contribution equal to 5% of the employee's eligible compensation. In this case, Abbott Laboratories sent the IRS a proposed amendment to offer a student loan benefit program. This is all employees would be eligible. It was voluntary. It's a voluntary student loan program, repayment program, where that employee would get a 5% match, even if they did not make an elective deferral to the plan. In August of 2017, the Internal Revenue Service released a private letter ruling saying that basically that Abbott Laboratory could make a 5% 401k match to employees that paid at least 2% of their compensation towards student loans. This was not, according to the IRS, a violation of the contingent benefits rule. The employee can receive the match or the non-elective contribution, but not both. And also to be noted that the employee can opt out of this program, the student loan program, at any time. So what this IRS private letter ruling determined for this particular taxpayer was that an employee who makes a student loan repayment and therefore receive a student loan repayment non-elective contribution is not in violation of the contingent benefits rule. I would say that the private letter ruling did not provide any opinion regarding the federal tax consequences. This ruling did not provide any opinion on whether the plan satisfied the requirement under Code Section 401A. And then also this private letter ruling should not be used as as precedent for any other companies. But the ruling does provide a framework for employers to make the student loan match on a pre-tax basis by integrating it into a matching formula under the 401k plan. In addition, the ruling effectively allowed this particular employer to treat student loan repayments as if they are elective deferrals to the 401k plan for purposes of calculating the employer match to the plan. Since the private letter ruling may not be used or cited as precedent, here are some plan design consideration. In a safe harbor 401k plan, it may be necessary to make both the match and a student loan repayment non-elective contributions for those who make both deferrals and student loan payments. Pursuant to the private letter ruling, a student loan program would encourage participants to make this student loan repayment rather than contributing to a 401k plan. So student loan contributions do not count towards the ADP testing, and that match that employee would receive do not count toward the ACP testing. And this, of course, could be considered an adverse impact on the ADP ACP testing. But those are just some of the plan design considerations that you need to think through as if you're deciding to implement a student loan repayment program. So moving forward to December 2018, Ron Wyden, a Democrat, introduced what's called the Retirement Parity for Student Loans Act that became effective this year in 2019. Here are some key features. Employers can now make matching contribution, or these are proposed, but the employers could make matching contributions under 401k, 403b, and simple plans. This particular proposed legislation would provide matching contributions to continue to qualify as a safe harbor for non-discrimination testing, and it opens the door for student loan repayment to be treated as elective deferrals and to qualify for corresponding matching contribution. Other features include this particular proposed legislation would apply to higher education expenses, and the same rate for matching should be used. It should be the same rate for matching contribution for student loans should be the same rate for elective contributions. And the last two features of this proposed legislation is that this particular safe harbor non-elective contribution should apply special rules to employees. So student loan repayment can only be taken into account to the extent that employee has not made the maximum annual contributions to the retirement plan. And last, it does restrict any to the extent where the plan would be considered discriminatory for highly compensated employees. There's a safe harbor mechanism where that non-elective contribution would satisfy the non-discrimination testing. This particular proposed legislation that I mentioned, this bipartisan legislation, is a part of the Retirement Security and Savings Act, which has a bipartisan backing. So I wanted to give you an update before we go to our next slide. And as a recent update, there were 6 Senate Democrats that reintroduced the Retirement Parity for Student Loan Act as recent as early this week, May 13th. And what this did, it permitted 401k plans, 403b plans, and simple plans to make matching contributions to employees as if their student loan repayments were salary reduction. And again, as I stated earlier, this is a voluntary decision on the part of the plan sponsor. Another recent update that we just received was that we got word that the IRS is working on guidance to answer those many questions on the issue that was raised pursuant to the 2017 private letter ruling. And it is definitely great news for employers because employers are just trying to figure out what they need to do, if any. But I will say that the IRS is not accepting any further private letter ruling or issuing a private letter ruling or any other plan design or proposed amendments at this time. So stay tuned for further guidance from the IRS. Our next topic is hardship withdrawals. The Bipartisan Act of 2018 mandated changes to the hardship withdrawals for 401k plans and 403b plans. Although the provisions are effective January 1, 2019 for calendar year plans, the proposed regulations do not require changes for 2018 and 2019. Effective January 1, 2020, following the issuance of final regulations, certain changes will be required. There are at least 5 significant changes on the hardship withdrawal. The first one would be, the first one, not the second, but the first one would be 6 months suspension of elective contributions is eliminated. The old rule was that employees were not allowed to make any elected deferrals for 6 months. The new rule allows for that, removes that 6 month, but that 6 months suspension will not become effective until January 1, 2020. The second change is that employers are no longer required to first take a loan. So if the plan wanted to take advantage of a safe harbor, then under the old rule, then the employee needs to take any and all withdrawals, including loans. The new rule stated that, well, certainly the employee should try to attempt to take all the withdrawals, but they're no longer required to take any loans before receiving a hardship withdrawal. Employee representation of what we consider no available assets to satisfy the need, the immediate and heavy need. The old rule states that in order for you to determine that immediate and heavy need is based on all facts and circumstances. What the new rule is stating, beginning no later than January 1, 2020, is that the employee must be required to provide a written statement indicating no cash or liquid assets to satisfy the immediate and heavy need. The plan administrator, I should note, can rely on the participant's statement unless the plan administrator has actual knowledge to the contrary. I believe the last requirement has also changed from not being able to satisfy a need from any assets to not only to satisfy the need from any reasonable available liquid assets, cash on hand, or assets that can be readily converted to cash. One of the fourth change is investment earnings can now be distributed. Old rule, you couldn't, under the 401k plan, you were prohibited from distributing investment earnings. This excludes 403b plans. The new rules, earnings on elective contributions can be distributed in a 401k plan. And lastly, under this proposed rule, hardship withdrawals, not proposed, but the rules won't become effective till 2020. Safe harbor contributions, QNICs, and QMAX, that's qualified non-elective contributions and qualified matching contributions, were not permitted to be distributed in hardship withdrawals. The new rules allow for the safe harbors, QNICs, and QMAX to be distributed. Some additional changes to the hardship withdrawal rules. The rules expanded the list of immediate and heavy financial need. This need includes need for spouse, child, or dependent, or a primary beneficiary. The need also has been expanded to damages to principal residents that would qualify as a casualty loss deduction. And then there's one more automatic immediate need, and that is for need to cover expenses and loss on account of federally declared disaster, such as a major hurricane or tornado. So deadlines for this amendment and communications. I gave you the effective dates, and so I would say that the IRS noted the amendments are required by the last day of the second year after they are added to the IRS requirements, our IRS required amendments. And that includes any changes in connections with the regulations and optional changes. While this gives most plans until the end of 2021 to document how they implemented these changes, the better practice would be to amend closer in the time to which that change is effective. And I believe employees should be notified with hardship withdrawal changes before or shortly after they're implemented, so that the hardship withdrawals are effectively available to everyone and there's no potential for discrimination in the availability of hardship withdrawals. Now I will end, this is the end of my sections, and I'm going to hand it over to David so he can do the announcements. David?
Thank you, Charlene. Before I advance to the next slide, I just wanted to let you know that we're going to be doing something during this webinar that we've never done before. And if you're a current client or a service provider with whom we currently work, we would really prefer to limit this to those of you on the webinar who perhaps we haven't had an opportunity to meet before. So what we're doing is we're going to give away 2 VIP lunches. And what is a VIP lunch? A VIP lunch is when you and a guest either come to Hall Benefits Law or we provide lunch. If you're not in Atlanta, we understand. We serve clients in 25 states. We will send you lunch and do a virtual lunch through Skype, and we're offering you an hour with our principal attorney. And Ann Tyler Hall is a very accomplished ERISA attorney. She's known nationally both as a speaker and for the work she's done on behalf of plan sponsors. And we want to give you an hour to discuss the employee benefits legal compliance topic of your choosing, or we can talk about whatever you want. So if you're interested in taking advantage of this offer, we're giving away 2 VIP lunches for you and a guest here at our office or virtually through Skype. And you need to send an email to admin@hallbenefitslaw.com with the subject line VIP lunch. And the first 2 folks who do that, we will be reaching out to you to schedule your VIP lunch shortly after the webinar. So thank you for your attention. Thank you, ladies, for indulging me. And at this point, I'm going to pass the mic to Rena Felton. I apologize. I'm going to pass the mic to Deborah Andrews.
Thank you, David. I want to start off by providing a broad overview of multiple employer plans. And these plans are also known as association retirement plans. Multiple employer plans, or a MEP, is a retirement plan that's maintained by 2 or more unrelated employers that is not under a collective bargaining agreement. Plans under a collective bargaining agreement are referred to as multi-employer plans. And these terms are often confusing, but just remember that multi-employer plans are basically union plans. And I'm talking about multiple employer plans today. There are several types of multiple employer plans, or MEPs. And there are special rules that apply to MEPs under the Internal Revenue Code and under ERISA. My focus today is going to be on the ERISA rules, but I do want to mention a very important rule under the Internal Revenue Code that applies to MEPs. The Internal Revenue Code treats a MEP as a single plan, and so it provides that if one employer participating in the MEP fails to meet a requirement, then that will cause the entire plan to lose its tax qualified status for all of the employers participating in the plan. This is referred to as the bad apple rule, and that is one disadvantage of a MEP. However, there are several benefits of participating in a MEP, and the main benefit is a reduction in the administrative costs and burdens for the participating employers. All right, under ERISA, a MEP can be treated as a single plan or as an aggregation of separate plans. The main benefit of a MEP being treated as a single plan under ERISA is that the MEP will be responsible for handling most of the ERISA obligations. So if it's an ERISA covered plan, then most of the responsibility is going to be shifted to the MEP level. For example, the MEP will be responsible for filing a single form 5500 on behalf of all of the participating employers. If the MEP is not treated as a single plan, then each employer participating in the MEP will be treated as having a separate plan and therefore responsible for fulfilling its own ERISA obligations, which mean, for example, each employer is going to be responsible for filing its own Form 5500 and obtaining a separate fidelity bond. When determining whether a MEP is a single plan or an aggregate of separate plans for ERISA purposes, the starting point is ERISA's definition of employer. Now, under ERISA, an employee pension benefit plan, such as a 401k, includes plans established by a quote-unquote employer. And the term employer means any person acting directly as an employer or indirectly in the interest of an employer. And this includes a bona fide group or association of employers. Now, lately, there has been a lot of focus on when a bona fide group or association of employers are treated as employers for ERISA purposes. The Department of Labor traditionally took the position that for a group or association to be treated as a single employer for ERISA purposes, the members of the group had to be tied by a common economic or representational interest other than just the provision of benefits. And this is referred to as the Commonality of Interest test. This is based on the facts and circumstances, and some of the factors that the DOL considered was how the members were solicited, who was entitled to participate in the plan, who actually participated in the plan, and who controlled and directed the activities of the association. An open MEP is a type of MEP in which any employer may join the MEP regardless of its industry or geographic location. And in 2012, the DOL took the position that an open MEP would not be treated as a single plan under ERISA because the members did not have a genuine organizational relationship. Okay, well, in an effort to make it easier for small businesses to offer benefits to their employees through a MEP, on August 31st, 2018, the President issued an executive order directing the Department of Labor to consider expanding circumstances in which employers could participate in a MEP and it qualify as a single plan. Well, in response to that executive order, on October 22nd, 2018, the DOL issued proposed regulations clarifying the definition of employer for ERISA purposes. Under the proposed regulations, a bona fide group or association will meet the Commonality of Interest test and therefore be treated as an employer if the members are in the same trade, industry, line of business, or they have a principal place of business in the same state or metropolitan area. The proposed regulations don't address open MEPs, but based on the DOL's prior decision on open MEPs, it appears that the open MEP still wouldn't qualify as a single plan under the proposed regulations. I also want to mention that the DOL's proposed regulations apply to defined contribution plans, not defined benefit plans. Under the proposed regulations with respect to MEPs, the requirements for determining what a quote-unquote employer is, it basically mirrors the DOL's regulations for determining an employer for purposes of association health plans. We discussed association health plans in a prior webinar in February. So in July 2018, several states filed suit alleging that the DOL's final rule with respect to the definition of employer for purposes of association health plans was an unreasonable interpretation of employer for ERISA purposes. And on March 28th of this year, the district court ruled that it agreed that it was an unreasonable interpretation of what an employer was under ERISA. Now, as I previously mentioned, the DOL's definition under the MEP proposed rules parallel the definition of employer for purposes of the association health plan rules. Therefore, the future of the definition of employer under the MEP rules is uncertain. However, the DOL has released Q&As addressing the court decision and recently filed a notice that it plans to appeal the decision. In the meantime, the DOL could delay finalizing the proposed regulations on MEPs until the litigation involving association health plans is finalized. Okay. There has been a lot of bipartisan legislative proposals to expand MEPs, so the DOL rulemaking may not be necessary. On April 2nd of 2019, the House and Ways Committee approved retirement legislation referred to as the Secure Act, which stands for Setting Up Every Community for Retirement Enhancement. One of the provisions of the Secure Act is designed to encourage employers to provide retirement plans. And the act would permit unrelated employers to pool their resources by participating in a new type of MEP if certain requirements are met. And this new type of MEP would be referred to as a pooled employer plan. So in addition to pooled employer plans, this legislation would also get rid of the quote unquote bad apple rule. Some of the other key provisions of the Secure Act include a provision that relates to automatic enrollment. Automatic enrollment is a common feature added to plans to increase employee participation. Employers automatically enroll employees in the plan unless the employee affirmatively elects otherwise. Well, under a safe harbor rule, the cap on the default contribution is 10%, and under the Act, this cap would be increased to 15%. There is also a provision under the Act that deals with part-time employees. Currently, employers may exclude part-time employees from participating in a plan. Part-time employees meaning those who work less than 1,000 hours, 1,000 hours a year, excuse me. Under the Act, under the Act, part-time employees working at least 500 hours for 3 consecutive years would be permitted to participate in the retirement plan. Also, there's a provision that deals with safe harbor 401k rules in an effort to make those plans a lot more flexible. It would eliminate the notice requirement and also would permit amendments to become a safe harbor plan anytime before 30 days prior to the end of the plan year. Okay, I'd like to end my presentation by just briefly mentioning rules with respect to missing participants, because this issue is on both the IRS and the DOL radar, and it frequently arises during an audit. Now, the Department of Labor and the IRS has not issued any formal guidance on missing participants for ongoing plans that are not in the process of being terminated. However, the DOL has provided guidance on steps that should be taken for terminated defined contribution plans, and this guidance is useful in considering steps for dealing with missing participants for ongoing plans. So under this guidance, certain steps must be taken to locate missing participants, including using certified mail to try to contact participants at their last known address, checking related records such as human resource files, records of other benefit plans offered by the employer that the missing participant may have participated in, identifying and contacting beneficiaries, as well as using free search tools such as social media. Because missing participants is on the priority list for both the Department of Labor and the IRS, I think it's important for plan sponsors to establish procedures to locate their missing participants, and you also may want to take a proactive approach and establish procedures to try to reduce the number of participants before they go missing. All right, and with that, I will hand it off to Rena.
Thank you, Deborah. And now we're switching gears to talk about the new 403B plan remedial amendment period, or RAP. As a background, it wasn't until 2009 that the IRS issued regulations that provided a written plan document requirement for 403B plans. However, and in contrast to 401k plans, the IRS neither provided for a determination letter program nor a pre-approved prototype or volume submitter plan. In fact, the IRS provided limited guidance as to what it expected in the 403B plan. So basically, document providers were on their own. Specifically, in 2013, the IRS announced that document vendors were allowed to submit documents to the IRS for approval. Now, the IRS began issuing opinion or advisory letters beginning in March of 2017. Employers that adopted the pre-approved plans could then rely on the letter that the form of the document they adopted satisfied the requirements of the Code Section 403B. Based on the new introduction of the pre-approved plans, the IRS then created a remedial amendment period, or a RAP, which allows an eligible employer to retroactively correct defects in the form of a written 403B plan by timely adopting a pre-approved plan or timely amending the plan document. Plan documents may now be retroactively adopted to the first day of the wrap period to obtain retroactive relief to that date. If a plan completes the adoption of a pre-approved document by March 31st of 2020, and it's retroactively adopted to January 1st of 2010, January 1st, 2010 being the first day of the remedial amendment period, and March 31st of 2020 being the last day of the remedial amendment period. They could retroactively adopt the plan and also cure any defects in the form of the plan, which will then be deemed corrected for all the years after 2009. However, if a plan was adopted after January 1 of 2010, then the first day of the remedial amendment period would be that later date of the initial adoption. It may be that so basically, wraps cannot be used to correct operational errors. And so this has always been the case. And so we want to make sure that that's understood, that you cannot use a remedial amendment period to correct an operational error. And some questions that plan sponsors may have is it a requirement to restate the plan in a new pre-approved plan document? It's not a requirement at this point, but it may be that some plan designs don't easily fit into the pre-approved format. And so plan sponsors are advised to review their plan documents to make sure that it confirms, to make sure and confirm that a restatement is not required, and also to make sure that any changes that have been made are correct changes. So what do we recommend? We recommend that if you're going to use the remedial amendment period, that you start early. You should gather all of the prior plan documents and all of the prior amendments that you have, and also reconsider some of the aspects of your plan design, and also conduct a compliance review, because again, you do have a limited window by which you can go ahead and retroactively amend for any plan form errors. So now we're going to talk about retirement plan correction program updates. And there have been two specific updates that I'd like to talk about. First, I'd like to talk about the voluntary compliance program submissions, or VCP submissions. On September 28th, 2018, last year, the IRS issued Revenue Procedure 2018-52. Which updated the consolidated statement of EPCRs. And this was primarily to establish new procedures for the electronic filing of the VCP submissions. Basically, electronic filing of the VCP submissions are now mandatory, and this became effective January 1 of 2019. However, the requirement to actually file electronically did not go into effect until April 1st of 2019. So from January 1st through March 31st, the VCP applications were allowed to be made on paper as before, or electronically using the new procedures. And so employers had a choice, but now since we're past April 1st, paper filings are no longer being accepted. So how does this work? Electronic filers must first create an account on pay.gov, and if you have an account already, there's no need to set up a new account. An authorized representative can file on behalf of a plan sponsor, but under the new rules, the sponsor has to specifically grant that authority. And the IRS has, the IRS has actually provided some sample language. The plan sponsor is also required to sign and submit what's called a penalty of perjury declaration. And this basically is going to affirm that the truth, accuracy, and completeness of the submission is agreed upon by the plan sponsor. Electronic filers have to complete and sign a Form 8950 VCP application only on the website. You can no longer use the paper filings. This has to be filled out on the website. And then also all of the required documents have to be uploaded into a single PDF file. Now, many of the same documents as before are going to be required. So for example, there were no changes made to the information that must be submitted about the failure, how and why it occurred, and the proposed method of correction, as well as any earnings or actuarial adjustments. Also, filers still have the option to use the Form 14568, which is the model VCP compliance statements, and any of its schedules separately or together. Now, what's important to note is that files that are larger than 15 megabytes cannot be processed. And so a portion of the documents for larger submissions can be provided by fax. We recently submitted a VCP earlier this year, and it was about 105 pages, and that turned out to be approximately 9.6 megabytes. And so, as you can see, we were well under the limit. And so just to give you an idea of how big 15 megabytes could actually be. User fees have to be paid through a method that's available only on the website. So what ends up happening is that the payment will generate a confirmation once it's paid with a tracking number that identifies a submission. And so plan sponsors will have to make sure that you're keeping up with this tracking number. We want to caution that the IRS recently indicated to us that they are aware of certain payment issues associated with making the ACH payments online. This was based on a recent conversation that we had with an IRS agent who's in the employment plans department. So specifically, some payments are expected to be rejected once the IRS tries to charge the checking account to pay the fee. This was discovered because due to recent changes to the pay.gov website and how the system basically reads the leading zeros to a routing number. And it basically, the changes made it so that it does not read the leading zeros as part of the routing number. And unfortunately, since the rejection isn't automatic, as in the case of when you use a credit card, filers won't know that the payment was rejected right away. So some filers may be contacted by the IRS to provide, and I'm using my air quotes here, correct routing numbers. So we just wanted you to be aware of that's something that I don't believe is widely known, but it was based off of a conversation that we recently had with an IRS agent. Other VCP-specific changes affect the procedures for anonymous submissions, penalty of perjury statements when submissions are modified, and circumstances in which the IRS may not contact the filer before issuing a compliance statement. EPCR's guidance has also been revised to reflect certain developments, including the simplification of the VCP user fee schedule, the consolidation of the IRS programs for pre-approved plans, and the elimination of the IRS's letter forwarding program for locating plan participants. So the next correction program update that we want to talk about, and this is will be the close of my portion of the presentation, is that the self-correction program have been expanded under EPCR's in a revenue procedure 2019-19. So this became effective April 19th of this year. And these new rules under EPCR's expands the type of disqualifying defects that may now be corrected under the SCP or the self-correction program. The RevProc expands the retirement plan sponsor's ability to correct plan document, plan loan, and certain operational failures under the SCP. So while the update replaces the previous version of EPCR's, the changes primarily affect the SCP process. The other EPCR programs, the EPCR's correction programs, the VCP and the audit cap, are largely unchanged. And so we are going to focus our attention on the changes under the SCP. So in the past, if you fail to timely amend a plan document for changes in the law or regulations, you could only correct this by filing a VCP application and paying the user fee, unless the correction, of course, is made through an IRS audit, and you'd have to use the audit cap. This new procedure will now permit self-correction by retroactively adopting that required amendment. This self-correction approach is only available if the plan has a favorable determination letter, or for a pre-approved plan, a favorable opinion or advisory letter for the most recently expired 6-year remedial amendment cycle. Operational mistakes, as you know, can often result in participants receiving higher benefits than they would have received under the terms of the plan. Under these new rules, if the plan sponsor is willing to provide for the higher benefit, then these type of mistakes can now be corrected through a retroactive amendment as well. The new rules, like the old rules, will allow for self-correction of a plan loan operational defects resulting from, as we all know, the defaulted loans. So what's new is the ability to self-correct without having to report the failure as a deemed taxable distribution to the participant. Now, this is significant because in the past, the only way to correct a defaulted loan without tax consequences to the participant was by filing under the VCP and paying a user fee. But under the new procedure, a deemed taxable distribution may be avoided as long as the defaulted loan is corrected by either reamortizing the outstanding loan balance or making a single corrective catch-up contribution. Also, loans that don't meet the exceptions of the code or loans that are in default that is not otherwise corrected under the new RevProc, plan sponsors may now report the deemed distribution in the year of correction instead of the year of failure on the Form 1099-R. An additional change with regard to the plan loans is the ability to correct the failure to obtain spousal consent to a participant who is pledging their account balance as collateral for the loan. So very few 401k plans are required to obtain spousal consent in these circumstances because the plan doesn't offer an annuity distribution option. However, in cases where consent is required but not obtained, it will now be possible to self-correct this defect by simply notifying the spouse and obtaining consent retroactively. Now, if the spouse will not retroactively consent to the loan, then that correction will have to be made under a VCP filing or through the audit cap. A final change deals with the operational defects that occur as a result of permitting a participant to obtain loans that exceed the number permitted by the plan terms. In this case, a retroactive amendment can be adopted as long as the amendment doesn't violate the code's qualification requirements and as long as the plan loans, including the loans that are in excess of the number that's permitted under the plan terms, were available either to all participants or solely to one or more participants who were classified as the non-highly compensated employees. This type of amendment can now be adopted as part of the SCP self-correction as well. And so now David is going to close us out.
Thank you so much, Rena. I was panicking because I thought I was missing my last two slides, but what do you know, there they are. So just a reminder of who we are, I would direct everyone's attention to the handouts section in your GoToWebinar portal. There are two handouts there. One of them is specifically related to retirement plans. We do a fiduciary legal compliance review service. We do this for health and welfare as well, but since we're talking about retirement plans, the handout there in the handout section is a detailed description of the 12 bullet point style issues that we tackle when someone engages us to work with them in a fiduciary legal compliance review for their retirement plan. So I want to make it very clear, each of these is something that you could do on an a la carte basis, but what we recommend is that you take a look at your plan with one of our attorneys on an ongoing basis for 12 to 18 months so that we can memorialize what you're doing right and fix the things that are non-compliant. The second handout is simply a little bit more about Hall benefits law, because the purpose of these webinars is really to educate, not to advertise who we are and what we do, but that is a part of my job. So I appreciate your attention to that. So that's the second handout is called Proactive ERISA Lawyers Protecting Your Business. And it just talks about our mission as a firm, who we are, where we come from, what we believe, and how we work with plan sponsors, in addition to a little bit of information about each of the practice areas. And we are unique in that we do focus on all different areas of employee benefits, not just retirement plans, not just health and welfare, not just executive compensation, but we have attorneys who collaborate and who are able to work with plan sponsors in a very holistic manner. So our focus is on proactive legal compliance. And then the other aspect I want to share with you here at the end of the presentation today is simply that we are very active on social media, and this is part of our mission to educate. So if you will follow us on LinkedIn, Twitter, we have a YouTube channel, and we are also active on Facebook. And these are not opportunities for us to share a quote a day or to tell you about the 10 best places to retire. We want to give you substantive information about how to be proactive in the way that you approach employee benefits. So if you're interested in being that type of plan sponsor, or you're a service provider who's interested in learning more about how to provide those types of services to your clients, we would urge you not only to follow us on social media, but to sign up on our website. We do monthly HR alerts. We'll send you details about upcoming speaking engagements. You'll be invited to future webinars. And generally speaking, you'll be more up to date on employee benefits, legal compliance in general. So with that, I do want to thank you for your time. I do want to remind you that if you'd like a copy of Ann Tyler Hall's new book, you may request a physical copy of that book by emailing admin@hallbenefitslaw.com. And in the subject line, if you'll just put the word book and make sure that you include your mailing address, we'd be happy to send you a copy. And then everyone who registered for today's webinar will be receiving a digital version of that as well. And that book is also available on Amazon. So thank you for your attention today. We appreciate it, and we look forward to seeing you in our next presentation.